Good morning. My name is Dwight Mitchell. That's DWIGHTMITCHELL. I'm here today to share my tragic experience with Dakota County Social Services. My children were illegally taken away from me without court order and retained by CPS because of false accusations of long-term abuse. The cold hard fact that's been the most difficult for me to understand is that CPS knew these allegations were not true almost immediately after they started their investigation. This was based upon an official New Jersey document that CPS had requested and received that proved I was fit to care for my sons, yet still they kept my children. For 22 months, I was allowed no phone calls, no visits, no letters, absolutely nothing for 22 months. It was 22 months of lost smiles, lost hugs, and lost time spent together as a family. Almost 2 years of not seeing or hearing from my middle son. I was not even being told where he was. So every night, I went to sleep not knowing where he was. It's really hard to know what to say when someone asks me how I feel about the abduction of my children by CPS, since it's been the most traumatic experience of my entire life. Initially, I went through a range of emotions: shock, disbelief, finally overwhelming frustration and despair over something as simple as ordinary parental discipline. I still find it hard to believe that something like this happened to me. What I mean is I'm well educated, I'm a Christian, homeowner, well-traveled, clean-cut, have my own business, and have been an upstanding member of society for 53 years prior to this incident. Like all parents who love their children, none of us would expect child abuse to enter our homes through a government agency like CPS. Thinking I would get my children back quickly, I did everything that CPS asked of me. Although CPS never provided me with a safety plan, a case plan, or a reunification plan as required under Minnesota state statutes. After 5 months, CPS returned my 6-year-old and my 15-year-old son to me, but refused to return my 11-year-old son. They knew I was a fit parent and our household was safe because they had just returned 2 of my sons, with the youngest being 6 years old. Furthermore, 2 CPS psychologists evaluated me and said I was fit to parent my children. CPS was ordered by several judges to reunify my 11-year-old son over a period of 17 months, but instead, CPS elected to initiate the termination of my parental rights for no valid reason whatsoever. When a social worker files a petition to terminate your parental rights, they are asking the court to take away your children forever. For the less fortunate, the state does not provide you with an attorney, nor do you get a jury trial. You get one hearing before a judge with the county attorney presenting the state's case against you before your child is stripped out of your arms forever. The state of Minnesota will provide you with a lawyer and a jury trial for stealing a pack of chewing gum, but will give you neither when they take away your child forever. Now, put yourself in my position. There is something fundamentally wrong, flawed, and unjust about the entire Minnesota termination of parental rights process. To say this one facet of CPS is unconstitutional would be an understatement. Reaching my limit with CPS, I decided to go on the offensive. I requested my discovery or the files in my case and received over 600 pages of official Dakota County documentation. After reviewing all of the information, I learned that CPS was intentionally violating my constitutional rights by fabricating evidence to the court to illegally retain custody of my children and omitting documentation or evidence that was favorable on the return of my son. There are approximately 85 pages of key official Dakota County documentation attached to my civil rights complaint as evidence of their illegal activities. The most heinous act performed by CPS was when they attempted to terminate my parental rights. The social worker fabricated in his affidavit to the court by stating I had abandoned my son in Minnesota. I had made no efforts at reunification, and they had not been in contact with me for over 5 months. When in fact, the exact opposite was true. Furthermore, all of these illegal actions were reviewed and approved by supervisors. After I reviewed all this discovery information, I filed pro se a motion to the court to vacate all previous court orders, to dismiss my case, and to enforce my valid custody court order by ordering that CPS return my son to me. I presented the court with all of the fabricated and misleading evidence I had uncovered by CPS for the illegal removal and detention of my children. When in court before Judge Erica McDonald, none of the Dakota County state defendants, including the guardian ad litem, denied any of the information I presented before the court. How could they? It was their own official documentation. Instead of fighting back, continuing the retention of my son and the termination of my parental rights as they had started, Dakota County and CPS requested that all charges against me be dropped, that my case be dismissed, and that my son be returned to me immediately so that Judge McDonald would not have a chance to rule in my favor on the motion before the court and find them guilty of their illegal activities. In fact, they had brought my son to court with them that day and returned him to me immediately. It's been over 2 years since I've gotten my son back, and I still have nightmares about the whole ordeal. On top of this, my son has completely changed. Prior to his abduction, he was confident, outgoing, athletic, loved to ride his bike, play soccer, tennis, ski. Now he's shy, introverted, never wants to ride his bike or go outside to play. He doesn't play any sports whatsoever anymore. The abduction by CPS ruined my son's life and changed him forever. Without a doubt, this has been the most horrific experience of our life. The tragic part about this entire ordeal is that these morally bankrupt individuals showed no remorse whatsoever. In fact, they were brazenly arrogant to the end. By the end of my proceedings, the situation changed. The institution charged to look after the health, safety, and welfare of innocent children had in fact become the child abusers for me. For 2 years, I tried to put this behind me, get on with my life, since I had finally gotten all my boys back. But the whole ordeal was weighing heavily on my soul. I spoke with several other victims like Andrea Cole, Starshema Jones, Declare Tripp, just to name a few in our association, and learned that we all shared the same experience in our attempt to get our children out of the clutches of CPS. I then investigated further by reading the Minnesota Department of Health and Human Services annual report for the last 10 years. And I learned this was happening all over Minnesota, to all ethnic races. But it was happening to African Americans at 4.0 times more than Caucasians, and to Native Americans at 5.6 times more than Caucasians. The truly baffling part is that this is still happening with federal grants and programs in place to decrease disparity of African Americans in CPS. So I wonder what the federal funding has been used for. Reading the Federal Office of the Inspector General reports, I learned of misallocated federal funds, claimed unallowable costs, inadequate caseworker training. Reading further, I learned about the Child Welfare Targeted Case Management System, the cost for caseworker services and reimbursement under federal Medicaid, that this was a revenue source for county agencies. In their documentation, it states, monies may be used to maintain or expand designated preventive services and found to fund new positions. I also learned that the federal audit, the last federal audit, 118 claims were reviewed and found to be invalid at a cost of $3.5 million. I knew something had to be done about this tragic situation. I felt it was unconstitutional and that an investigation was needed. But the longer I waited to take action, the worse I felt. It had been almost 2 years. I knew it was going to be a monumental task to go up against the government, a proverbial David against Goliath. But knowing what happened to our family and what I believe CPS was doing to other families unchecked would not allow me to stand idle and be apathetic. I also felt that God had given me the financial means, the intelligence, and the responsibility to expose what I had uncovered and to help other less fortunate CPS victims. In my effort to help thus far, I formed the association Stop CPS from Legally Kidnapping. We have about 250 members so far. I created a petition on change.org. We have close to 1,200 signatures. I created a pro se self-help webpage. I've spoken to Minnesota legislatures. I've spoken for the governor's legislative task force on child protection. And finally, with the assistance of Eric Cardell, of the law firm of Mormon, Cardell, and Erickson, filed this civil lawsuit for the association and my family with the intent of making a lasting change in the Minnesota child protective system. Thank you very much.
Thank you, Dwight. I knew I should have gone first. It's a hard act to follow. I'm known around here, my name is Eric Cardell, as an attorney who's made a career suing the government. So you can imagine, me asking the question, why am I here with Dwight? And the reason I'm here with Dwight is because when Dakota County Child Protection Services targeted Dwight and his relationship with his children, they made a very, very bad decision. They made a decision to go after a gentleman who was a great father, great businessman, and he is everything you'd want to be. And over this ordinary use of corporal punishment, one instance of ordinary corporal punishment, he lost his family for 22 months. And from the very first moment, there were racial undertones here by what the social workers were saying. Why do you African parents so quick to spank your kids? That's just wrong. And is that what we want in Minnesota? I mean, we have these reports saying that African American kids are 5 times as likely to be grabbed by child protection than Caucasians. But here's why Dakota County Social Services and Child Protection made a mistake. And that is that Dwight has a background as a successful businessman. Dwight has analytical and counseling skills that have led him to negotiating multinational contracts on behalf of his company in 100 nations. Can you believe that? And you know what he is? He's a business process consultant. These big multinational corporations, they open up their checkbooks and say, Dwight, we've got analytical problems. Could you help us? And you know who needs the help right now? The Department of Human Services, because they have a child protection system that isn't working. Yeah. So Dwight could have given up. He had his children back. Oh, they're beautiful children. And he could have given up, but he talked to people who told him, give up, Dwight, give up! You gotta let go! And Dwight took on this challenge. I don't think it's David and Goliath, it's Dwight and Goliath. Right? We have Goliath, now we have Dwight. And Dwight's taking on Goliath, but you know something? When Dwight came to me, he had analyzed everything already. And I vetted it. I said, Dwight, you got it all right, and your presentation's all right, except that the Department of Human Services and Child Protection Services at the county level have really mismanaged their statutes. As we all know, the department drafts the statutes in this area that the legislatures kind of sign off on, and the legislature has not done a good job of protecting the parents in this regard. So when we look at the statutes and we look at the complaint, count one is simply this. Do any of you know whether child protection can take your child if you give an ordinary body spanking? Now we know a private school can, because private schools are allowed to do corporal punishment in Minnesota, but can a parent? Well, apparently several places in the statutes it says a parent can use reasonable force to correct a child. But then it always says, as long as it doesn't cause any injury, as long as it doesn't cause any mental injury, as long as it doesn't threaten any injury. And so child protection takes the view what? Every ordinary corporal punishment by a parent, it makes you subject to a child protection proceeding. That's just wrong. Now, we've done some research looking at states around the nation. There are some deep blue states, I mean, states like Massachusetts, Oregon, Hawaii, who've decided, well, wait a minute. We have a lot of single parents now. We have a lot of single fit parents. If we have vague and ambiguous statutes that authorize child protection to seize those kids away from single fit parents, then the government ends up raising the child. And we all know, don't we, the government's horrible at raising children. And these dark blue states, I mean, they not come to the grounds that the family, some sort of spiritual thing. They come to the practical point that we can't have the government raising our children, and when we do, we offend people like the African American community, because you're taking those children away illegally. So it's one thing to take away children legally, it's another thing to take them away illegally. And the right that's being violated is parents have a right to discipline their children. That's a constitutional right, and that includes ordinary corporal punishment. The second problem with the statutes, count 2, is that the definition of child in need of protection or services is unconstitutionally overbroad. So we're right back to the same issue, right? That basically the word game is child in need of protection or services means the parent's unfit. So no single parent that's fit should have a child in that category. When you have an ordinary spanking, an ordinary, like, get out of the road, when your child runs into the road, I saw that this weekend, where a mother had to grab a 3-year-old and pull the kid back and give him a little spank at the bottom. So the point is that child abuse? Is that justification for losing your child, like in Dwight's case, for 22 months? No. And it's causing social unrest. We have lots of racial problems here in Minnesota. We don't have to have this one. That is grabbing children from African American families on unconstitutionally vague and unconstitutionally overbroad statutes. The third count is, what are we doing not narrowly tailoring these statutes to protect ordinary spanking? I mean, now we have the dark blue states saying we got to allow spanking because we don't want the government to raise these children. We have the red states who've always said that, like Oklahoma. So why are the blue and red states like dialing it back on spanking? Because they know if they go after spankers, all these single fit parents are going to lose their kids, even on allegations, not even the truth. And so Minnesota is in this position, and you all know it, and Child Protection will tell you. I mean, they've already started hearing the phone calls that a parent's ordinary spanking is a public health crisis. Right? We've heard that for 30 years, and now the deep blue states are saying, no, it's not. We're not going to get federally funded social workers, supervisors, county directors, and the whole apparatus going when the parent has an ordinary spanking. Some of these states have a provision. If the child protection investigation leads to the conclusion that there was an ordinary corporal punishment, then the investigation ends and the files are expunged. Dwight, he still has a child abuse file. It hasn't been expunged. It hasn't been erased. That's just unfair. Finally, the statutes are so poorly drafted that there's actually more protection under the CHIPS definition for children who are residing with the victim than the victim itself. In fact, it's easier under the definitions to show that a child residing with the victim is CHIPS than it is for the victim themselves. This shows a carelessness on the part of the department in carefully drafting statutes. When you're drafting this area and regulating the relationships between parents and children and authorizing them to be taken away, it ought to be done carefully. Those 4 counts are the 4 counts in the complaint with statewide ramifications and statewide injunctions that we're seeking. In our research, we came to the conclusion that Minnesota's Child Protection Services has become oriented towards its federal funding of approximately $8 billion a year. So in the 1990s, the federal government said we're going to pay for all this. And so instead of focusing on keeping Minnesota's families united, in fact, that law was repealed back in the 90s, particularly we want to keep single fit parents and their children united. So in my view, Dwight Mitchell's lawsuit was long overdue. Dwight Mitchell's lawsuit is the end of Minnesota's 30-year experiment of using federal funds to take children away from single-fit parents. If Dwight Mitchell wins, as people like him have won in the states of Massachusetts, Oregon, and Hawaii, the racial disparities will go away, or at least most of it. And many, many more single-fit parents in Minnesota will remain united with their children, which is good for everybody. Now I'd like to introduce an attorney who's supporting the cause, Rhea Borman.
My name is Rhea Borman Spears, and I'm a Minnesota family attorney who is volunteering my time with an organization called Village Arms. There's an advocate who started that agency, and that's where I'm spending my time based on how passionate I have begun to feel about this issue after having some clients with the same situations as Mr. Mitchell. Village Arms is not a party to this case, but the advocacy that's being provided is addressing these issues of racial bias and the disparate treatment of African American parents, and we are glad that Mr. Mitchell is boldly seeking to bring about change. The same things that happened to Mr. Mitchell are happening to African Americans in Minnesota at an alarming rate, and you'll see there are individuals behind me. They are here based on their situations and their separate cases. There are statistics that are documenting that this is happening, and they're no secret. They can be accessed, the public can read them, so I'm going to tell you about them. 60% of cases involving African American children are assigned to the family investigation path for discretionary reasons, as compared to 39% for Caucasian children. This is an avenue with which social workers are able to use their own judgment, and often that is clouded by racial bias. The family investigation track is more punitive than the assessment track, and it involves the court, places a maltreatment finding on the African American parent, and that finding often causes additional problems down the road, like loss of employment, housing, and it increases the family's likelihood of further child protection involvement. The incidences statewide of children assessed by child protection among white children is 13.6 per thousand, as compared to 42.7 per thousand for African American children. In the face of the same allegation, an African American child of 2 or more races is removed from their home at a rate of 3.1 and 4.8 times higher than their white counterparts. Once maltreatment has been substantiated, white families with the same or more egregious allegations are more likely to receive services that allow their children to remain in the home, while the African American children are removed from theirs. The rights of African American parents are terminated at higher rates, and African American children of 2 or more races are between 3 and 5 times more likely than white children to become state ward. African American children of 2 or more races are least likely to be adopted before age 18, and African American children are the highest population of children moving from child protection to juvenile detention. This racial disparity is documented by the Department of Human Services, and despite federal funding to combat the disparity that Mr. Cardall spoke about, DHS is failing because the numbers of African American children in the system is actually increasing significantly, despite billions of dollars of federal funding being spent. I'd like to highlight and make clear that African American children are also being removed from fit homes that pose no risk or threat of harm to the children. That is probably the piece that has led me to be so passionate about this. There are cases where there's evidence that the parent is fit, there is evidence that the home is safe, and yet the children are removed and the proceedings take months, even years before they're corrected. County workers are padding petitions, fabricating evidence, and manipulating facts to support the removal of these children, and then subsequently the termination of the parents' rights. When pushed to answer about how workers are being held accountable in situations where documentation proves that they've submitted falsities to the court, the Department of Human Services has yet to give an answer about how those workers will be held accountable. The trend we found is that the county's preference is to place these children in Caucasian homes, And then the children are alienated from their parents, family, and culture and community. In almost every case, all relatives have been shut out, not just the parent they were removed from. The county does not follow procedural due process for removal, which would require a risk assessment, and the creation of a safety plan, as Mr. Mitchell mentioned, was not created for him. A safety plan, by the way, for those who aren't familiar, would allow the children to stay in the home. It would figure out what mechanisms are in place, what individuals are there for support of that parent, and most importantly, it would avoid the trauma of removing the children and placing them with strangers. When the children are removed, the parent's statutory rights of relative placement for their children are often denied, and relatives are brushed off by social workers when they get involved and try to find out why the children can't be placed with them. I've heard repeatedly that they were told they were unfit, or that they had to go through a lengthy process of paperwork and jumping through hoops to become the placement option, and oftentimes that takes months or is years down the road. If we consider the outcomes at each decision point across the child welfare continuum, we see clearly that this system is not helpful, but rather harmful and abusive to African American families, and especially traumatic to children. We all know that healthy families are vital to the success of our children and ultimately our state. Everyone has a stake in ensuring Minnesota's child protection system is fair and equitable. Help us address these racial disparities, please. And the injustices faced by these families through your support. And one way to do so would be to contact your representatives in the House and Senate. Which leads us to.
Good afternoon. I am Senator Andrew Matthews. I represent Senate District 15, Mille Lacs, Sherburne, Benton counties, and small pieces of 3 others in Wright, Kanabec, and Morrison. And I'm here today. I am not a party to this lawsuit, and I did not encourage this lawsuit, but I am encouraged because of this suit, because it has become very clear to me that some drastic changes are long overdue. And I've gotten into this because, first of all, I was asked to serve on the Legislative Child Protection Task Force last year, and I joined that and was sitting in those meetings throughout last summer and fall. And we heard story after story. Mr. Mitchell, this is where I first met Mr. Mitchell when he came and shared his story, and that turned into some lengthy one-on-one conversations with myself to hear about his situation and what he was trying to do to bring more justice and fairness back to our situation. And after story after story after story, this is no longer something that can have a blind eye turned to. It's time for standing up and making some changes in our legislation and in the way that departments approach this. And this is something I want to try to dig into. I also have a constituent issue in my own district that has been extremely troubling, and it's mirrored many of the situations and statements that Mr. Mitchell and others of these families have shared. And so there are just too many stories that have come around of negative, wrong impacts, and there needs to be some drastic changes at the department. When an unelected state bureaucratic agency can grow into a gigantic, almost a 4th branch of government, and be able to take the driver's wheel in legislation and try to direct the legislative body, we have a significant problem, because they do not have the same accountability as I do as an elected senator from my district, or as the executive branch does. They are so detached that it's very difficult to bring accountability. We are their accountability, and we need to work for some significant changes. And my goal is to try to ensure justice for everybody. Can't be just for those that may have means, like Mr. Mitchell, and the wherewithal to stand up and fight back. But it needs to be for everybody, regardless of their situation or their social status. It needs to be factually based on whatever the situation is in every individual family, and whether there's a true violation of the law or not. And I believe that there are just too many cases where a department or county workers have come in with a very high level of intervention right from the get-go, when a first step of a low level of intervention could probably resolve many of the situations before they get to this point. So that's why I'm here, and I'm grateful that Mr. Mitchell is carrying this on, and we're going to keep looking and crafting what legislative fixes could help work with this situation too. Thank you.
Thank you, Senator. I was wondering if there were any questions?
Yes, sir. Mr. Mitchell, just to help us understand, it sounds like, it was just started with a spanking? Did a neighbor see it, or how did the whole thing start for you?
It started with a spanking. My former wife told my son that if I ever spanked him to call and tell the police. So he told the babysitter that I had spanked him, and his mother said to call the police, and so that's what the babysitter did.
Over just a spanking?
Over just a spanking.
One spanking.
Yes, it was the first time he was spanked.
And then you had a conviction for that, or there's a ticket issued, or how does that work?
Well, what actually happened is that I was charged with malicious punishment of a child, and the state statute is so low in Minnesota that anything that causes pain, it's called non-bodily harm, but if it causes pain, whether that be physical or mental, is grounds for being convicted. So what Judge Spicer did from the bench, realizing for ordinary parental discipline, he actually offered me what's called an Alfred plea. And what that is, it allows me to maintain my innocence while closing out the case. Because I told him, I said, I need to finish this so I can get my children back. So he says, I understand, Mr. Mitchell, I'm going to offer you this Alfred plea. I'm going to fine you $100. Let's get the case over with so you can go get your children back. So this happened within 90 days of the incident, and it took me 22 months to get my son back after the judge said, I understand. If anyone reads the transcripts, they'll hear the judge saying this.
And what's the motivation for these social workers to fabricate, to lie, to do what they're doing, which seems to happen a lot?
Well, I personally feel there's no rational basis. When I was doing my study, I was looking at how the social workers do their billing, and how it's called the caseworkers transactional management system, TCM. And so they're allowed to bill the federal government back for every child that services is being provided for, or every child that's in foster care. So when they say a service, if they just go out to visit the child, if they say the child is in need of protection or service, and they enter that person into the case management system, they can bill the federal government for one caseworker, for a supervisor, and for every service provided. So I was looking at the billing for my son. For foster care was over $1,000 a month. For the services for the doctors, for the state worker, it's all being billed back to Medicaid. So I can only deduce that it has something to do with that. But most people, like myself, we just want our kids back. So we don't understand the dynamics of what's happening. So we're just trying to do whatever they say to get our kids back. And then the time just keeps expanding, because each time you go to court, it's 1 month after another.
Mr. Mitchell, what would you want specifically changed in state statute that would prevent this from happening?
Well, like other states like Hawaii and Oregon, there really needs to be a state statute that clearly defines that ordinary parental discipline, such as corporal punishment, is not illegal. In fact, in Minnesota, in one statute it says parents are allowed to discipline their children using ordinary corporal punishment, and then further in the section it says, well, as long as it doesn't cause any pain. Well, that's sort of an oxymoron. No pain. That's the threshold. It's that low. Same thing for neglect. So, because my wife was there, she was charged separately also with neglect. and she wasn't even home when the incident happened. She was at her girlfriend's house. And they said, well, you failed to stop this. She's like, well, how can I stop it if I'm not home? So they gave her her own petition also, and then she was in under the services track herself.
Mr. Mitchell, the other members of your group, your association, are they also people that were caught up in the system because, like, they spanked their kids, or?
No. Actually, a lot of the people, as I was just talking about negligence, I have people in my association who are grandparents who want to try and have the children live with them. Their parents will be caused, say in my situation, they spank, they say the husband spanks the child. Well, all the children are taken out of the household. So they're people that have been taken out for discretionary reasons, neglect. So they're, all sorts of people. As a matter of fact, corporal punishment is probably the lowest removal rate. Only 10% of the people in Minnesota are removed from corporal punishment. Over 40% is just negligence or discretion. Caseworker says, I want to do this, and I'm going to do it. And so I have a lot of people in the association that are actually facing that problem. And so I can identify with them because I know what I went through. And like most, I had, the foresight, business expert to say, I want my discovery and my facts. Most other people do not. So after I read through 600 pages, I saw exactly what was being done. So then, I went to get my children back by filing motions pro se. Well, most people don't know how to do that. They don't know that they can ask the judge to dismiss the case. Your Honor, here is my court report. The social worker gives the court report. Well, here's my court report. The social worker gives facts. Well, Your Honor, here's my facts. Here's my evidence. So they don't tell you these things. So I'm trying to make people informed. So I think everyone deserves a fair shake. Sure.
One thing that sort of surprised me as a lawyer was that I approached this as a lawyer. And I was so surprised the way that these federally funded agents, the county agents, manipulate the court process into an administrative proceeding. And so I'll just give you one example. That Mr. Mitchell had cooperated with all the county officials and all the psychologists hired by the county say he was fit, and everything was lined up to get the last child. But it came to the 15-month anniversary of taking the child, and on the 15-month anniversary of taking a child, what happens? The federal government's for the foster care run out, and so the county didn't know what to do. So it filed a termination for parental rights with no factual or legal basis just to continue the federal funding. So you see how a bad system ends up infecting everything? Our culture, our politics, even our courts. How could a government file a frivolous petition after 15 months on a single spanking incident against Mr. Mitchell? That's your government. You're accountable for that government abusing Mr. Mitchell and his children. And so we need to fix it. I mean, it's our government. We fix it, right? We got a senator here who's going to get legislative reform. We got a team leader here. Mr. Mitchell, other team leaders are out here, and we can fix it. But the first thing is just to sit down and say, we need a court injunction stopping child protection from using this definition. They have a vague, constitutionally overbroad definition for child in need of protection or services, which is not nearly tailored to meet a compelling state interest and has no rational basis. So that was my contribution. Mr. Mitchell had everything else figured out, and I figured out the whole thing was corrupt. And so then what happens is you have to ask the court, and this is something we don't want to ask, we've got to ask the court to shut down child protection. Now that sounds horrible, right? That's horrible, we can't shut down child protection. Well, we don't have to, we can say we're going to shut them down and give them 90 days to fix it, right? If something's so bad that needs to be statutorily fixed, then you ask the court, shut them down.
Yes.
And then give them the state legislature 90 days, 120 days, whatever they need, to focus on, you can't do this to single fit parents. It's a disaster because the government is horrible at raising children. And so we have to be really careful about this line when you take a child away from a single-fit parent, because the consequence is the government raises the child. And at one point, Mr. Mitchell asked the supervisor at the county saying, my son doesn't need counseling. Dwight, it's not you why he needs the counseling. It's the separation from you. That's why he needs the counseling. So who's causing the trauma? Who's ruining these children? Obviously, it's the government, but it's our fault too, because we're partially responsible for what the government does, so we have to fight back. But this would have never happened if there weren't billions and billions of dollars of federal funding coming in, and they turned their mind towards the money, follow the money, and they forgot about keeping families united. And Rhea, to her credit, she introduced me to the group here, and probably the most important day of my life, because it opened up my mind to what's going on. And I have great empathy for this idea that there's a little bit of a cultural genocide going on here. And what really makes it even worse is an illegal cultural genocide. Think about that. Your Department of Human Services is causing a cultural genocide to the African American family, and they're doing it illegally. That means you're going out of your way to do it. It's not unintentional, it's intentional. The U.S. Constitution, it's on a piece of paper, it's accessible to everybody. Inside there, the parents have a right to discipline their children. And here, the Department of Human Services and the County Child Protections, they grab the children on these vague and unconstitutional standards. And it's got to stop. And when you see what I've seen talking to these people, you're causing a lot of social unrest, and that only goes to a bad place. And what we need to do is start taking this seriously, reunifying families, and the first thing to do is rewrite these statutes.
Senator, what have you had feedback from the domestic violence industry, Liz Richards or Michael Dittbrenner, as far as their support for any of these changes, or?
So the changes and the way that the law needs to be rewritten was recently brought to me from Mr. Mitchell and Mr. Cardall. So we're early on in the process, but as they've alerted it to me and based off of all of last year's stories, it's clear that something needs to be done. So it's going to be a long process. No, I haven't reached out with those groups at this point, but this needs to be a long and thorough process, so that we make sure it gets done right. And we're early on in that process, but it is this important, with me, with other members of the task force, other legislators that are in on this issue. It's going to be something that will take time, and we want to do right.
Now, how long has the task force been meeting, and have they come to any conclusions, or?
The legislative task force has been around since before I got here, which is only since the 2016 election. So I was added to it last year. They were working on their task last year was working on a large variety of the governor's recommendations. So they covered, quite a broad gamut that they're working for to come up with proposed legislation for the future. This is one specific area that I think needs to get drilled down deeply at some point.